Hi there. I'm Jim Zirin. Welcome back for more conversations. Ukraine aside, there is much to talk about on the legal front these days. What should we make of former Attorney General Bill Barr's memoir, defending his 22-month stewardship as the nation's chief legal officer under Donald Trump, now #1 on the bestseller list? The possibility of the first black woman on the Supreme Court. Should Clarence Thomas recuse himself in election-related cases because of his wife's heavy involvement in the big lie? Or should he resign? What of Judge David Carter's opinion it was more likely than not that Trump committed federal crimes on January 6th? And where does Merrick Garland stand on this? What is to be made of the 7.5-hour gap in the White House phone logs on January 6th? When will Garland indict Mark Meadows, Peter Navarro, and Dan Scavino for contempt of Congress? And as if this weren't enough, how about Trump's solicitation of Putin to provide dirt on Biden and his family? Back with us with the answers to these questions is Elie Honig. Elie is a top former prosecutor in the Southern District of New York, a CNN legal analyst, and himself the author of a terrific book about Barr entitled Hatchet Man, presenting his perspective on Barr's run at the Department of Justice. Welcome back, Elie.
Jim, thanks for having me. I'm not sure I'm going to be able to give definitive answers to all of those questions. I think a lot of them are unknowable, but I am happy to discuss them with you.
Well, you're a lawyer, so give us qualified answers.
Exactly. I know I'll hedge appropriately.
Ketanji Brown Jackson, let's start with her. Do you think she was fairly treated by those Republican senators?
No, I don't. Something that's changed in my view in the way Supreme Court nominees are handled now is the old rule used to be if you were the party that was out of power, the minority party, not the party holding the White House, but a nominee came up and that nominee was qualified and not completely extremist, you would vote yes. Justice Scalia got in something like 98 or 99-0. Ruth Bader Ginsburg was something like 96-3. So what seems to be happening now with Judge and I think soon to be Justice Jackson is everybody agrees she's qualified. I've not heard any serious person say in any serious matter she's not qualified. What people are doing now is a combination of some Republicans are trying to grandstand and just get a TV moment by asking her questions that have absolutely nothing to do with their job. And she's done a very good job of displaying judicial restraint and saying that's not a question for me as a judge. And I think also just trying to score political points by just saying no. And both sides do this now. Democrats vote no on qualified Republican nominees just for political reasons. Justice Gorsuch was certainly qualified. I think Amy Coney Barrett was qualified, but virtually every Democrat voted against them. And Republicans are doing the same against Judge Jackson, not exactly for the same reasons and in the same way, but the same bottom line.
Well, what about her downward departure from sentencing guidelines in child pornography cases? Is that a serious problem?
No, I think that was a overhyped, miscast attack on Judge Jackson. So, Jim, as you know, in the federal sentencing system, there is a set of guidelines. It's a thick book that all AUSAs, I used to carry it around to every court appearance. And you have to calculate based on the type of offense and based on the offender's prior crimes, you end up with a number. It's actually, there's a grid and you say, okay, his criminal history is this, the offense level is this, and therefore the offense range, and it gives you a range, 78 to 97 months, 18 to 24 months, what have you. That is very important, but it's not binding and it's not mandatory. And in fact, judges often, about half the time, go below that range in all cases. But if you look at this specific narrow category of child pornography possession cases. We're not talking about molestation cases. We're not talking about creation of child pornography. What they were focused on was only possession of child pornography. 59% of all sentences in those cases end up below the guidelines because there is a fairly broad, not unanimous, but a fairly broad consensus across the judiciary, regardless of whether the judge was put on the bench by a Republican or a Democrat, that in those cases, the guidelines tend to be too high. I don't necessarily agree, but a lot of judges do agree. And it is in the majority of those cases, defendants get sentenced below the guidelines. And Judge Jackson did just that in many, but not all of her cases. So I didn't see that as a big deal. I think that that was done in an exploitative and sensationalistic way by some of the Republican senators.
Well, Senator Hawley, it seemed to me, did everything but slap her face.
I mean, look, he's grandstanding, and he's looking. There was nothing of substance really to attack, and he's going for a moment. He's trying to create a soundbite, but he really didn't succeed. If you watch the exchanges, Judge Jackson did a very good job, A, keeping cool, right? I mean, talk about a judicial demeanor. She was totally unflappable, but B, explaining, you in Congress, respectfully, gave us judges the factors that we are to consider. And in every case, I went meticulously through those factors based on the specifics of those cases. And that's really exactly what you want a judge to do.
So you think she ought to be confirmed?
I do. I think I would vote for her regardless of my ideology or party affiliation, because A, she is qualified, and B, she is not an extremist of any variety. And I think that's all that one can ask for, I think.
Well, let's move on to a sitting justice who may or may not be an extremist, Clarence Thomas. He's run into some difficulties lately with a health problem and then the conduct of his wife on January 6th. What do you make of all that?
Yeah, well, obviously everyone wishes him well with his health. The issue with his wife has gotten to be very serious. So Justice Clarence Thomas's wife, Ginny Thomas, has long been known publicly to have fairly extreme, arguably extremist political views. You can disagree with her views, a lot of people do, but she's entitled to hold those views. What's changed now, what's different now is we've now seen that A, she was at the January 6th rally. She claims she left before the violence started, but she was there and encouraging the rally over social media. And even more important, she was in direct contact, texting Mark Meadows, asking him to take steps to try to overturn the election. And to me, what the problem now is, that makes Ginny Thomas, at a minimum, let's be charitable here, a witness, somebody who may get called on by Congress, may get called on even by prosecutors as a witness. What did you see? What did you do? Who did you speak with? And as a result of that, Clarence Thomas should have been past looking and should be forward looking, recusing himself from anything to do with January 6th. And Jim, as you know, this is a fundamental principle in public life. Prosecutors live by it. Judges are supposed to live by it, which is if you have any personal, familial, economic connection to a case, you remove yourself. The term is recuse yourself. You don't want to do anything that might even give the appearance of any conflict of interest. And the fact that Clarence Thomas has stayed on those cases really undermines his credibility and I think the court's independence. And I'll just give you one quick example, Jim. Clarence Thomas himself has recused himself off of Supreme Court cases a couple dozen times in his career, including
the VMI case.
1996, VMI, Virginia Military Institute. There was a challenge to VMI's males-only admissions policy. Clarence Thomas's son was a student at VMI. He did the right thing. He said, I'm out. It's going to look bad at a minimum. You know, almost sort of ipso facto, I'm not great with the Latin, but therefore he should have removed himself clearly from the January 6th cases as well.
Let's move on to another icon of the law, Merrick Garland. He was a judge. The president, it is said, has been critical of him because his thinking is too judicial, too objective, and he isn't really thinking like a prosecutor, ready to pounce on someone for an infraction. Do you agree with that?
Well, first of all, I have a problem with Joe Biden making those statements. I know he didn't make them publicly. I know he made them to his advisors, but he's a 50-some-year veteran of Washington, D.C., and he knows if he says certain things, they will get out. I am never going to applaud any president trying to put political pressure on the Justice Department with respect to specific prosecutions. This was a core fundamental criticism I made of Donald Trump and Bill Barr. Donald Trump was constantly calling on Bill Barr and DOJ to go after certain people and not go after other people. Now, Donald Trump did it overtly. He did it on Twitter. Biden is talking to his people behind the scenes. So it's not exactly one and the same, but I am categorically opposed to that. I think presidents should keep their mouths shut and have no view and state no view when it comes to what attorneys general do. And I will note, Joe Biden himself has had a bit of an opportunistic political turnabout, because shortly after Joe Biden was elected, he let slip to 5 of his advisors, who then talked to, I think it was ABC News, I forget if it was ABC or NBC News, that he did not want to see his Justice Department pursuing Donald Trump. And I think what this shows us is this has become such a political problem that now Joe Biden is sort of holding a finger up to the wind and saying, boy, this is really getting ugly. I better let it be known that I want him to prosecute. Moving beyond my criticisms of the president for getting involved or for trying to weigh in on prosecutorial decisions, I remain skeptical that Merrick Garland has his sights realistically set on Donald Trump. I think the pace of this investigation is inexplicably slow. We're now 15 months out from January 6th. In fairness, Merrick Garland took office in March, so we're 13 months into Merrick Garland's tenure. If Donald Trump committed a crime here, he should have been charged by now. You can't take 15, 18, 24 months to charge this crime. And every day that passes, it gets more and more difficult politically. We've got midterms coming up soon. Donald Trump is all but announced, and he may soon actually, maybe someday soon, we don't know, actually announce his candidacy. So the longer Merrick Garland waits, the more any action he takes is going to look political. But, Jim, a lot of people sort of go back to the refrain of, well, what Merrick Garland's doing, what prosecutors always do. You start at the bottom and you flip people and you work your way up. That's not really true. And I can say that I was a prosecutor for 14 years, not good prosecutors. What good, aggressive prosecutors do is you look for, given the available evidence, what is the highest point I can start at? I went after mob bosses because I had good evidence leading right to their inner circle. I didn't say, well, hold on, let me start down at the very bottom of associates and take 6 months to flip them and flip them. Sometimes you can go right at the top. A lot of times you can go right at the top. And I argue that the public record and the evidence that we've seen from the January 6th committee is more than sufficient for Merrick Garland to go right at Donald Trump and his inner circle and start at a minimum, I wish he had started, but at a minimum, subpoena those folks and do serious investigation of them and not go from the guys in face paint who stormed the Capitol up to the Oath Keepers. I don't know that will ever connect in a linear fashion to Donald Trump.
Well, you have a number of revelations that have come out of the January 6th committee, and it kind of dribbles out. Yep. But you do have the subpoenas that issued and the ruling by Judge Carter in California that
Yep.
more likely than not Trump committed crimes. You do have the 7.5-hour gap in the White House phone logs. It seems to be an additional nugget of evidence that comes out every week, but no sign that the Justice Department is responding to any of it.
Well, let me say this. I mean, the Justice Department, we have seen with those subpoenas you referenced, Jim, which are now going into the financing and organizing of the rally, that's the first tangible sign that they're moving above literal ground level. But still, it's way too onerous and sort of myopic an approach here to say, we're just going to start with the guy with the bullhorns on his head, and maybe that'll lead to the rally organizers. I mean, it's not going to get to Donald Trump. The assumption here is that it's all one neat conspiracy, when in fact, I think it's overlapping conspiracies that aren't going to necessarily lead to one another. Yes, there's a lot of political pressure building for sure, and we're learning quite a bit of interesting information from the January 6th committee that I think underscores the need for Merrick Garland to not just take sort of, deliberate, slow, months-long action, but to go right at the power sources here.
Well, what about 3 simple cases that have been referred to Garland by the January 6th committee? The poster child being Mark Meadows, the former White House chief of staff. It's been almost 4 months since the criminal reference. The facts are very simple, very easy to establish. He was subpoenaed, he didn't appear, it's contempt. And then you have the 2 other Trump associates, Dan Scavino, who was deputy White House chief of staff, and you have Peter Navarro. They also raised the hand and perhaps the finger of a hand to the January 6th committee. and nothing seems to be done about it. What do you make of that? Do you detect from that a reluctance to charge close Trump associates with criminal conduct?
Yeah, well, certainly with respect to Mark Meadows, I think it's probably a little early on Navarro and Scavino because the full House of Representatives hasn't yet voted on them. But at some point soon, they presumably will, at which point this will go over to DOJ. But Mark Meadows, I think, is really interesting and telling. So it took Merrick Garland, I think it was 21 or 22 days to charge Steve Bannon, right? The first contempt referral that Congress sent over was Steve Bannon. Merrick Garland sat on it for about 3 weeks and said, yes, we're charging. Mark Meadows has now been sitting over on Merrick Garland's desk, speaking, hypothetically here, for 110 days. There is no way it would or should take Merrick Garland anywhere near that long to make a charging decision on Mark Meadows. Now, I do want to say this. It's a little bit of a dicey charging decision. It's not quite as straightforward as we subpoenaed you didn't comply because Mark Meadows did turn over quite a few very important documents. Then he stopped and he can still be charged for that part of it. But here's the real complicator. There is an internal DOJ memo from 2008, one of these Office of Legal Counsel, OLC memos that says, generally speaking, we, the Department of Justice, should not be charging White House officials for contempt of Congress if they invoke executive privilege. Now, it's not entirely clear that that opinion applies here because we're talking about is it a current president or a former president? Is this a good faith invocation of the privilege? But for whatever reason, Merrick Garland seems to be very much hesitant. I can only think of really 3 possibilities. One is he just legitimately hasn't decided yet, which to me is inexcusable. To take 110 days, this is a paper case. You don't need to be going through reams of cyber documents and bank documents. The record is the subpoena and the response. That's it. 2 is Garland already has decided he's not going to charge Mark Meadows, but he doesn't want to announce it because to announce it will A, cause political blowback, and B, will undermine the committee in its ongoing attempt to enforce its subpoenas. If Merrick Garland comes out and says, "Yep, we're not indicting Mark Meadows," then it's sort of game on for any witness to go, "Okay, we're going to defy this subpoena." So he may be thinking, "Let me at least leave some mystery out there." And then the third possibility is maybe related to the second. It's possible Garland is just sort of waiting and hoping that DOJ and Meadows come to some sort of negotiated agreement so that Meadows doesn't face the possibility of a charge and so that Congress doesn't get nothing out of it. But if I'm Mark Meadows at this point, I'm thinking, this guy's not going to charge me. I'm not going to negotiate anything. So I do fault Garland at a minimum for taking this long on that decision.
Okay, so let's just take a look backward, which Merrick Garland seems reluctant to do, and talk about Bill Barr and his book and his apology for his stewardship at the Department of Justice. Now, you've read the book. I've read the book. Did it change your view of that Barr was a hatchet man for Donald Trump?
No, not in the least bit. Bill Barr's book is exactly what I expected. And in fact, it's a big part of the reason I wrote my book. What Bill Barr does in his book is characteristic of what he did as Attorney General. He gives half-truths. He gives part of the story, but not others. He offers sort of cheap, lawyerly spins on things that maybe superficially appear convincing, but when you dig down a couple inches, you realize that it's just nonsense. I'll give you one quick example here, Jim. Bill Barr makes much of the fact that he stood up to Donald Trump in December of 2020 after the election and said, we found no evidence of widespread election fraud, which Bill Barr did do that. And he tells us that, and he has this grandiose story of how boldly he stood up to Donald Trump. The problem, completely omitted from Bill Barr's book, is any reckoning whatsoever with the fact that for months leading up to the election, he was the biggest cheerleader of the big lie. He was out there on national TV in Congress saying there's this massive threat of voter fraud. He was echoing Donald Trump's talking points. And I would actually have given Bill Barr some credit if in his book he said, I did say these things leading up to the election. And in retrospect, I was wrong and it was a mistake. And I was perhaps overreacting to some of the intelligence I was getting or whatever, but I wish I hadn't said them. And I sure hope I didn't contribute to any of the harm that came later. That would have been at least honest, but instead he just ignores this. And when he was confronted about it on CNN by Jake Tapper, Barr just offered this gobbledygook where he just sort of spun away and didn't at all confront what he had said. He just said something like, well, my concern was having a fair and even election. That's not an answer for why he lied to the American public. So it's a very disingenuous book, but it's done well. It's sold well. God bless him. Look, it's no skin off my back. Yeah.
But he authorized an investigation of fraud in the election before the vote was even certified.
Yes.
Now, isn't that contrary to the regulations of the Department of Justice?
He did. He tweaked DOJ's rules. He made a public announcement. Do you remember this thing with the allegedly nine ballots they had found sort of hidden in Pennsylvania? And he did a whole press release on it. And it turned out there were 7 ballots and they weren't even all for Trump. And it was an obvious clerical error. I mean, so he really abused and misused his platform as Attorney General to push this narrative. And I'll tell you another one. When he went on NPR, Bill Barr, in the summer of 2020, and started telling all these stories about how dangerous election fraud and mail-in ballots and counterfeiting, it was so bad that a couple weeks later, NPR, the staid NPR, had to write an article that you can Google entitled "NPR Let the Attorney General Tell a Falsehood on Our Air." And then the article quotes various election experts from MIT and elsewhere saying that Bill Barr's comments were, quote, ludicrous and nuts. So that's really bad when you're the Attorney General and you're telling lies that flagrant. That really undermines DOJ, and he really did help fan the flames that led to January 6th.
What comes through in the book, and perhaps you'll agree, is his excessive partisanship, his extreme partisanship. I mean, he goes back to his peak at the media 30 years before because they highlighted George H.W. Bush's ineptitude about supermarket scanners. But he goes on, I mean, even about Poland and Ukraine and Russia. And this is before the invasion. He says we ought to come to terms with Putin, and we've misjudged Putin. We ought to give him the benefit of the doubt. And there are other examples that he talks about in the book. And didn't that infect his decisions as Attorney General?
I feel very vindicated by Bill Barr's book, Jim, because I think the last chapter or second last chapter of my book is entitled Culture Warrior. And in that chapter, I take on the question so many people asked, why? Why would Bill Barr have done this? Why would this well-known, more or less forgotten guy who had plenty of money and had already been Attorney General once and was sort of respected in mainstream conservative circles, why would he have agreed to become Donald Trump's Attorney General and then lied his face off during it? And my answer was, he was power hungry. That's okay. Plenty of people are power hungry. But also he's an ideologue, and not just in the political sense, but in the cultural sense. And we found these things that he had written and said in the 90s, where he rails against secularist culture. He blames, quote, the homosexual movement, that's Barr's term, for so many of the ills in our society. He says, we Catholics need to retake the hill and regather the flock and retake society. And he not just admits that in his book, he celebrates it. He's an open, overt culture warrior. Now, I have no problem whatsoever with someone who's religious in their private life. But to say I'm going to let religiosity, this extreme view of religiosity, animate everything I do as Attorney General is a big problem. And I'll tell you something, Jim. On the political angle, Bill Barr admits and even brags about his politicization of DOJ. I mean, I wrote about the obvious things, the things we all knew about, his intervention in the Flynn case, his intervention in the Stone case, on down the line. Bill Barr, actually, there's a little anecdote in his book that's so telling to me, which is the day Mueller finished testifying on Capitol Hill, and it was sort of a dud, and it felt like the whole thing was over and it hadn't gone well for Mueller. Bill Barr writes in his book that he and his advisors had a champagne party in his office. They had a literal champagne party. And somebody asked him about that. I think it was Savannah Guthrie on NBC, and said, doesn't that suggest you're political? I mean, he said, no, we just felt like it was an important moment that needed to be commemorated. I mean, come on, they were literally popping champagne.
So we have to wrap up, and I do have a question for you, Elie Honig. This has been just marvelous. We can agree Bill Barr was a partisan. We probably can agree that Merrick Garland is more objective, more deliberate. But the question I have for you is, do you think Merrick Garland's going to indict Donald Trump or his inner circle anytime soon?
No, I don't think so. We don't know, Jim. You and I don't know. All we can do is read the signs. If I had to guess, I would guess no. And, with Merrick Garland, I almost have the opposite criticism in a way of Merrick Garland, in that he is so conscious of doing anything that might be perceived as political that he's really sort of hamstrung himself and the department in his decision making.
Anything that might complicate his decision. So, Elie Honig, thank you so much for coming by. Thank you for coming by. Tune in next week for more conversations. Please visit our website at jimzirinconversations.com. And good luck, take care, and all the best.